SJC-12399, Commonwealth v. Marisol Vallejo.
Ms. Kiley, good afternoon. When you get settled, you may commence.
Good afternoon. Rebecca Kiley on behalf of Marisol Vallejo, who appeals from an order of the Boston Municipal Court setting as a condition of her probation a restitution order in the amount of $140 to compensate the victim for the time that she spent at the restitution hearing in this case. There are two questions in the case, one factual and one legal. I'd like to begin with the judge's erroneous finding that Ms. Vallejo was able to pay the $140. As this court knows, in Commonwealth versus Henry, it held that a judge cannot issue a restitution order that the defendant is not able to pay as a condition of her probation. And the uncontroverted evidence at the restitution hearing here was that Ms. Vallejo was not able to pay the $140. She testified and provided documentary evidence that she was out of work because of a back injury, that she lived in public housing, that she had no other income, that she lived only with her son, who was a student and did not work. And the Commonwealth did not cross-examine her at all at the hearing and did not challenge her position at the hearing that she was not able to pay the money. The Commonwealth never argued below that she could. And in a motion for reconsideration, she brought further evidence that the Boston Housing Authority had set her rent at the amount of $17 per month. And the judge, having heard all of that evidence, made no adverse credibility finding. The only relevant subsidiary finding that she made was that Ms. Vallejo was indeed out of work because of her back injury. But she nonetheless concluded that Ms. Vallejo was able to pay the $140. And there just isn't any evidence that supports that conclusion. And so for that reason, we ask this court to reverse that finding.
Can I ask, just because Henry is a probation case, this is a quaff, right? There's no probation involved in this.
There is probation involved, Your Honor. Yes,
Okay.
she was sentenced to 1 year of probation. This was a first offense OUI, and so the typical disposition, which happened in this case, involves the imposition of the 24D program. I believe it's a 30-week.
So she had a year to pay $140. Is that, or did she have to pay the $140 in a month? I wasn't sure about that.
She, by the time the restitution hearing happened, and then after the time that the judge took to make her decision on the restitution hearing, I think 10 months were left of her probation. And the judge initially ordered that she pay it within a month, or that she present additional evidence that she was not able to pay it. The judge then refused to reconsider the order when she did bring additional evidence of her inability to pay, and said that that there would be monthly check-ins until it was paid, which I think the Commonwealth has interpreted as monthly check-ins to see if she's now able to pay, but they weren't. They were monthly check-ins to see if she had paid. The judge never revisited her determination that she was able to pay the money.
That's
she
a
never rescinded it.
clearly erroneous finding by
Yes.
the judge. So under the Henry rubric, the judge has to determine whether there's, at the inception there's an ability to pay.
Right.
And then you're going to argue, of course, that this category is legally
Right, yes.
impermissible.
And if I could just respond to one of the arguments in the Commonwealth's brief, we don't contest that the judge could have, and probably should, in a case where the defendant establishes her inability to pay at the beginning of a probation period, a judge probably should, compliant with Henry, say, like, okay, I find that you're not currently able to pay, but I'm going to require you to report to your probation officer any change in circumstances. For example, here, if you resume, if your back gets better and you're able to go back to work, you need to tell your probation officer, who's going to bring the case back before me, and then I'm going to determine if now you are able to pay the $140. But that didn't happen here. The judge simply determined, in the absence of any evidence to support it, that she was able to pay the money. If the court has no further questions on that, I will turn.
Just before we go, was there any evidence, I know she said she missed work. Was there any evidence that she wasn't paid?
Like as to the amount of loss?
Yeah,
I will,
he was working for a,
I think she works for the Mass Bar Association's Insurance Commission,
so do we have?
and I think that's in the record. I hope I'm not speaking out
I
of
think
turn.
that's right, that sounds, but I know she said she missed work. Do we have any record that she wasn't paid for those days because she was out?
I think only in that the judge must have implicitly
That her
believed that.
damages were lost wages.
Right.
For all the
Right.
hearings
Yes.
and that day. And then she gave a rate
Right,
that she gets paid at, and the judge
yes,
did the math and gave 100.
yes, I think that's right.
So what were the judges, the judge found she was, the judge didn't sort of articulate what she found, right, about the $140? She imposed the order, but she didn't say that she could or could not pay it up front, right?
Well,
She
she
was
said-
asking for $5,000 or a lot more money, and then the judge imposes $140 in restitution. Is that an implicit finding that she is able to pay $140?
Well, it wasn't just implicit. I believe it's at page 42 of my record appendix. There is a footnote, which is the only place where the judge deals with the ability to pay issue. Yes, it's footnote 10 on record appendix 42.
What does she say in footnote
And she
10?
says the court finds that she can pay the $140.
So this is a person who was working.
Right.
She's hurt.
Yes.
She had a real job. I mean, the judge may assume there's nothing about workers' compensation. I don't know,
She testified that she had applied for benefits but had been denied. I think she testified that she had applied for benefits and had been denied but would appeal that, or was waiting for a decision. But she testified that she was not receiving any
we have to
benefits.
find that's clearly erroneous. How do we find that's clearly erroneous? Imposing I mean, that's a small amount of money. I mean, it can be a large amount of money for someone with no money, but it's not $5,000. Henry was how much money?
Henry was just over $5,000.
So this judge reduces $5,000 to, there's a $5,000 request here too, right? There's some big requests here.
Well, it's actually, I think, over $20,000.
So there's a big request here and the judge orders $140.
Right.
How do we find that that's clearly erroneous based on this record?
How do we find that the determination that she's able to pay it is clearly erroneous? Because the only relevant subsidiary finding that she made was that the defendant was indeed out of work because of her back injury, and because the uncontroverted evidence, right, the unchallenged, uncross-examined testimony was that she had no other income, that nobody else in her household was contributing to the household, and that she lived in public housing. And then again, later, there was evidence presented that her rent had been the amount that the Boston Housing Authority determined she was able to pay in rent was $17 a month. So I understand that, $140 may have struck the judge as what the prosecutor calls a de minimis amount, but that is, of course, as you acknowledged, a relative thing.
We have to determine that the judge is clearly erroneous, but implicit in her finding is it's an ability to pay over the course of the probationary period, not right now, correct? So
Yes.
and as you point out, that's a 10-month period
Yes.
at that time.
That's right. She didn't do what Henry requires, which is say, how much can you pay each month and split it up that way. Instead, she said, just keep coming back each month and I'm going to check if you've paid it or not.
All right, thank you.
But if I could turn to the propriety of the order itself, because the restitution order in this case is unprecedented in Massachusetts. As far as I know, this court and the appeals court have not previously considered or upheld a restitution award that is for time spent at a court proceeding. And in Commonwealth versus...
This isn't just time spent at a court proceeding. If I'm remembering, this is time spent at a court proceeding for a restitution.
Yes.
It's even more narrow than that.
Well, yes, the court could decide it on that narrow basis. I want to just point out an area where I'm not in disagreement with the Commonwealth, because the Commonwealth argues generally that lost wages are compensable as restitution. And if these were lost wages, and many of the cases that they cite from other jurisdictions involve lost wages that result from injuries caused by the defendant. And I just want to be clear that if that was what we were talking about, I would only be arguing the ability to pay. I don't dispute that where somebody misses work because they've been hit by a car and they can't go to work, that is significantly related to the
That's
criminal conduct.
Curious, so suppose you had a case where someone had to go to court and testify for 3 days, and they documented it, and they said, here's what I get paid every day, and my employer wouldn't pay me. Would you argue that legally the judge would have the ability, if there was an ability to pay, to compensate for economic harm and lost wages for time missed testifying in court?
No, that's, our position is that the restitution standard in Massachusetts, which is adopted from the Florida causation test that requires a showing both of a causal connection, that is but for cause,
Right.
and also a significant relationship between the criminal conduct and the economic loss, that second part of this requires the court to conclude that these are not, that this is not an economic loss that flows from the defendant's conduct.
So if someone hits me over the head with a baseball bat,
Right.
and I now have to go to court for 3 days and testify, and I can't, and I build houses and I can't apply my carpenter trade, and I miss 3 days, wouldn't my missed time from applying my trade be causally connected to you hitting me over the head with a baseball bat?
Causally connected, yes, it's definitely a but-for cause. And the jurisdictions that the Commonwealth cites in its brief for the idea that lost wages for time spent in court are compensable as restitution are all jurisdictions where that's either specifically authorized by statute or where the causation test is a but-for test. In Massachusetts, we don't have a but-for test. We have but-for plus significant relationship. And we adopted that from Florida, and Florida courts, and I cite these in my reply brief, that have repeatedly looked at this question, exactly the question that you just posed, have said it's too attenuated, that there, the connection has to be fairly immediate between the conduct and the loss. And here, the way,
Right, because I get the distinction between the restitution hearing, which might be different. But I thought our case law said that the damages that flow from the criminal conduct,
well, it says,
economic harm that flows from the criminal conduct.
right, what McIntyre says, and McIntyre, I just want to point out, if I can, postdates Commonwealth versus Rotunda, a case whose dicta the Commonwealth has relied on here. The McIntyre test, again, is a causal connection, but also a significant relationship. And I see my time is up, but if I could just...
How about Rotunda? Because Rotunda expressly talks about, while such items as medical expenses, court-related travel expenses, property loss and damages, lost pay, or even lost paid vacation days required to be used to attend court proceedings might all be included in an appropriately documented restitution order. This was not the case here. So aren't we saying that this fits? I mean, it's dictum, but
Right.
this court likes dictum sometimes, right?
And may I respond? I think the first thing is that it's clear, even in the phrasing of that sentence, that it is dictum. And the issue in Rotunda was whether the victim of a verbal civil rights harassment and threats case who suffered no actual economic loss, whether it was appropriate for the judge to order $5,000 restitution in that case. And so I think this is pretty clearly far afield of the factual issue in that case. But the second thing that I want to emphasize is that Rotunda predates McIntyre. At the time of Rotunda, the causation test was just a causal connection test. And then a year later, in Commonwealth versus McIntyre, this court explicitly said, we're going to adopt the Florida approach to this. And at that point, the Florida cases that I cite in my brief had already been decided that said our significant relationship test means not time spent at court.
I don't get why substantial changes the matter. I mean, I understand there's a distinction between lost work and lost work related to going to court, but the causal connection is the same. This is all caused by the accident.
Well, in the sense of the but-for cause is the same.
Yeah, so my hypothetical, I can't work after I get hit on the head with a baseball bat because I can't climb ladders. I'm physically unable to work, so I missed 3 days of work.
Right.
3 weeks later, when I'm called to court, I can't work because I have to be in court for 3 days.
So I think at that point, it's still the but-for cause, but it's too attenuated to be to bear a significant relationship to the defendant's criminal conduct. And I guess the distinction that I would ask the court to draw is to distinguish between the lost wages that flow directly from the criminal conduct and those that flow from the attendance at the court proceedings, which I would submit are too attenuated. And if I could just make one final point before I sit down. The defendant's exercise of due process rights, whether by going to trial or by having a restitution hearing, shouldn't be conditioned on payment for those rights. And holding otherwise will force indigent defendants like Ms. Vallejo to weigh the risk of, that the hearing itself will require additional costs that she cannot pay against her right to contest, the claim of restitution, which here, the judge didn't find that any other restitution was appropriate except for the time that the victim spent in the courtroom.
All right.
Thank you.
Mr. Zanini.
Good afternoon, may it please the court. Jack Zanini for the Commonwealth. Depending on where you want to start, I think lost wages under rotunda is clearly covered. I also point out there's a statute I cited in the Commonwealth's brief, Chapter 276, Section 92A, which was adopted in 1980, 15 years before the restitution provision in the Victims' Bill of Rights. That is theft of an automobile. Theft of an automobile, if the defendant here had stolen this victim's automobile and driven away in it, then the restitution would specifically include by statute loss of earnings, replacement cost for the automobile, and out-of-pocket costs, which I think are consequential damages due to the theft of the automobile. Where this defendant drank vodka and then crashed into the vehicle and caused the loss of the vehicle, I don't see why, as a matter of statutory construction, when the legislature said restitution in 1995, they didn't encompass loss of earnings, replacement cost, and out-of-pocket from the 1980 statute, or as a matter of common law, why the court can't say, consistent with rotunda, yes, we think that these losses are encompassed by restitution under the Bill of Rights, which, as Justice Cordy noted in Dennehy, includes language about to the fullest extent possible restitution.
But isn't the problem, as your sister identified, that going to Justice Gaziano's example, if a defendant hits him over the head and he can't work, then that lost wages arises from the criminal conduct of hitting him over the head. If that defendant pleads guilty, then without burdening the victim and stipulates to the loss, then he will get his losses. But if that particular defendant says, no, I wish to exercise my right to go to trial, then suddenly the restitution that is being paid is greater, but isn't that essentially not because of the criminal conduct, but because of the exercise of the defendant's right to go to trial?
Perhaps, but we don't have that constitutional issue in this case. What we have is a defendant who has a restitution hearing, and this, interestingly enough, we have a little bit of an anomaly here. So there's a case called Molina in which this court said you can use reliable documentation such as letters and affidavits and other documents to establish restitution without the victim needing to appear in court. So I would suggest that when it's the plea tender occurred 1 month before Molina, the hearing is 1 month after Molina. So in this particular instance, the lawyers didn't get together and talk about it and say, are you really contesting? What part are you contesting? Which of the receipts and letters? So in the record appendix, there's a letter and then there's all receipts for the losses, and those were all submitted in court without objection from the defendant at the restitution hearing. So the due process issue might not, it's not presented for two reasons. You don't have a Sixth Amendment trial issue
But
at a restitution.
I'm not suggesting that all I'm saying is that in determining the scope of restitution, should that be part of what we are thinking when we're determining whether or not the causal relation is to the cause by the crime or caused by the exercise of a person's rights. There may arguably, if he were to find your way, there arguably could be a separate issue of whether that is now burdening his right to go to trial, because he's going to be paying more for going to trial than not.
Well, I'm not dealing with the trial at which you have a Sixth Amendment rights and other constitutional rights in play. We're dealing with the restitution here. And so we're thinking about equity, fairness, rehabilitation, restorative justice, all of these concepts. When we're thinking about that, and who bears the cost for the damages, who bears the cost for the harm, the defendant should bear that cost. Otherwise, you have an hourly wage worker who misses a day of work, for instance, because their car is stolen or their car is crashed into by the woman who drinks too much. In order to get that day of work hourly wages back, $140, they have to show up for a restitution hearing. When they show up for the restitution hearing, they're losing the day of work. Now they've lost 2 days of work. Well, if they only get the first day of work back, they're out of pocket for the second day of work. So why should they bear the cost of the loss? Then they're never made whole. The restitution remedy at that point is completely hollow and meaningless for that hourly wage worker. And it works the same probably for other people who don't get hourly wages and suffer some economic loss at work.
Have we ever done that before? Or any other state? It seems, you'd think this would have come up before. Do we have restitution cases where people recover for showing up in court?
Well, I think some of the other states, so I covered a number of jurisdictions in the brief, and I don't recall all of the jurisdictions and how all of it works.
Right. And you may have done this, or your sister may have done it, I just don't remember. Are there cases in these briefs where a restitution order was given for a court appearance, as opposed to?
I believe in some jurisdictions it is. I can't say with absolute certainty.
None of the cases cited in either brief is an example where someone's actually ordered this.
I don't recall right now.
And neither do I.
I'm sorry.
Okay.
So it may be in the brief, it may not. But as a matter of fairness, you can't gut the restitution remedy by saying you can get your day's wage back by coming to court, but then we're not going to give you your day's wage for coming to court. And if the documents under Molina, if all of the documents will suffice, but the defendant nonetheless insists, no, I want that person to show up so I can cross-examine them, it also doesn't strike me as unfair that, okay, it's not your trial, you don't have a due process right here at issue in the sense of the trial remedy, this is the restitution hearing.
But you do have a due process right to a restitution hearing.
Well, you have due process rights at that hearing to a limited extent,
And now you're basically saying the defendant has to pay for that. Because if the defendant were to say, I'm not going to contest it, no one need show, but if you want to actually contest it, then you'll have to pay for the cost of that person coming.
Right, a defendant has lesser due process rights, just like they have lesser rights at the probation surrender hearing, because the trial is over. The deal is done, you're guilty, and now we're in a place where you have lesser confrontation rights. And the court recognized that in Molina when the court said letters, affidavits, and documents may suffice. So now we're in the realm of equity and fairness. And in the realm of equity and fairness, I don't see how it's unfair to say to the defendant, as in this case, when you have unobjected to letter, unobjected to receipts, unobjected to bills that are all in, it was just that at this moment in time, people weren't really aware. Well, probably we don't need the victim here unless there's a real contest on it.
Except here, they asked for a lot more money than the 140. So this is a good example of where the defendant would certainly say, I wish there to be an evidentiary hearing, because I think the victim said, give me the money, and then it turned out the judge said insurance paid for everything.
The insurance did not pay for everything. Insurance paid for the totaled vehicle, the amount of the totaled vehicle. There were $10,000 in other claimed consequential losses, out-of-pocket costs that were not awarded here. And the defendant's real defense here was not a contest over the out-of-pocket cost, the consequential cost, the lost vehicle. None of that was contested. All of that came in unobjected to. That testimony and all that documentation was not objected to. The issue for the defendant was she made a claim of inability to pay. So under Henry, she said, I am unable to pay. That was her issue at this hearing, as it will be in many, many hearings where people are not well-to-do and are potentially indigent. The real issue is going to be inability to pay, as opposed to the amount of damages. And that's what this hearing was, frankly. And the judge, as Henry said, you can consider past and future prospects for employment, and I think that's what the judge did when she discredited the claim that this woman made, that I am unable to pay, at which she bore the burden of proof. The other small point I want to make, if I can, is that I think Henry might need a slight tweaking because the scheduling issue is problematic. We've seen it in a couple of cases. And also the idea that you impose the probationary term, which is to rehabilitate the person, before you figure out both the ability to pay and the amount of payment. And it seems a little problematic because if probation is to rehabilitate, and if part of rehabilitation is making compensation to the person you harmed and figuring out what you can make payment and how much you can make payment and what the loss is, that needs to be part of a unitary hearing. It's all inextricably interwoven. So the rehabilitation and the payment to rehabilitate and the restorative justice part is all part of one hearing. By analogy, you wouldn't say to a person, you're going to do 3 to 5 years in prison, and come back next month and we'll talk about what the aggravating and mitigating factors are in sentencing. So I think that there's a small piece of Henry that just needs to be probably tweaked a little bit in terms of having a unitary hearing at which all of these issues are considered. And if the court has no further questions, I will thank you for your time.
Thank you.
Court, all rise. Hear ye, hear ye, hear ye.